Hey guys, and welcome to today's video. Buckle up, because we're heading into Judge Shackelford's courtroom. And if you've been here before, you already know that this judge does not play around. Today's case features a pro se plaintiff who has decided to haul his ex-girlfriend into court over a set of claims so outlandish they could only come from someone who thinks Google searches count as legal training. Judge Shackelford is one of the stricter judges I cover on this channel. Sharp, patient until patience is no longer an option, and absolutely unwilling to let a courtroom turn into a soap opera. So the moment a case like this walks through the door, you know it's only a matter of time before the nonsense gets peeled apart layer by layer. We're about to watch a grown adult try to navigate civil procedure armed with nothing but confidence and a stack of arguments that crumble the second the judge asks a real question. And Shackelford, being the no-nonsense powerhouse she is, isn't going to let any of it slide. So grab your popcorn, settle in, and get ready, because this one goes off the rails fast. And Judge Shackelford is more than ready to steer it right back onto the track.
Mr. Jaffe. All right, this is the, are you here on Van Maren versus Davidson?
Yes, Your Honor. Jasmine Davidson is my client, Your Honor.
What's that? So
Yes,
I see Miss Davidson's here. And do I see Edward Van Maren?
Present in the courtroom, Your Honor.
All right, Edward Van Maren is present in the courtroom. So I have a motion for, sir, if you want to come on up, you can have a seat at this table. Oh, actually, you're going to be at that table over there, okay? All right, so I have a motion up for summary disposition. I've reviewed the motion. I've reviewed all of the documents that were submitted to the court. And is there anything that I need to be aware of?
Yes, Your Honor.
Your Honor, excuse me.
One sec. Can I get your appearance, sir? Can you tell me your name?
Edward Van Maren.
Okay, you can have a seat. Mr. Jaffe, give me your name.
Your Honor, good morning. Attorney Brent Jaffe on behalf of Jasmine Davidson. Your Honor, if I could address the court with regards to the motion that I filed, Your Honor.
Okay, so it's his motion for summary disposition. So Mr. Jaffe's going to go first, and then I'm going to hear your response, okay? All right, go ahead, Mr. Jaffe.
Thank you, Your Honor. The motion was filed, properly served on this individual. It was his poor decision to not retain a lawyer, because he's not a lawyer and he has no idea what he's doing. That being said, he never filed a response, Your Honor. This is well over a month ago. And not only did he not file a response, Your Honor, but I just want to make state for the record, and I have verification, but I don't need to get into it. This might be one of the most disrespectful people I've ever encountered in my entire life.
You, sir, have clearly never crossed paths with Chili DeCastro, a man who, for reasons unknown to science, has made it his personal mission to redefine the industry standard for what constitutes a walking, talking disaster. If the FDA ever needed a baseline to measure the purity of nonsense, they'd slap his name right on the label. This is a guy who treats frivolous lawsuits the way normal people treat morning coffee, a daily ritual, a comfort hobby, and apparently something he simply cannot live without. He files them with the enthusiasm of a toddler discovering crayons for the first time, except instead of coloring books, he scribbles all over the court system. So trust me when I say, whatever level of chaos you think you've seen so far, whatever flavor of courtroom confusion you're dealing with today, doesn't even scratch the surface of what Chili brings to the table. He has turned baseless litigation into an art form, and not the kind you hang on a wall, but the kind you quietly throw away the moment the artist leaves the room. And if you ever end up unlucky enough to face one of his filings, you'll learn very quickly that the nonsense meter has a whole new maximum setting you never even knew existed.
Personal attacks let's just get to the meat of the case. What is your motion based on?
Your Honor,
And just get to that. You guys don't have to like each other.
Failure to state a claim, Your Honor. This individual has never presented an iota of evidence to substantiate any claim that he's ever made, but rather this lawsuit was just an attempt for him to defame and harass my client. But again, Your Honor, no response. And respectfully, Your Honor, I would ask that this court hold this person to the same standard that an attorney would be held to. I would ask that my motion be granted accordingly, and this case be dismissed.
Sir, do you have a response?
Yes, Your Honor, I do. First and foremost, I was under the impression that defense never bothered to file an answer to this case to begin with. Moreover, as defense is trying to claim, my attorney was never present during the said case, the previous custody case between defendant and myself. I have been
So let me ask you this. Let me ask some questions. The parties were you married or dating?
dating.
All right, so how long, when did you start dating?
We were together 5 years.
When did you start dating?
2018.
When did you split up?
22.
Okay, so you split up in 22. Your allegation is that this,
If I may, Your Honor, we started in 17, not 18. Our daughter was born in 18.
okay. So basically the allegation is that a bunch of these miniature charges were made. At the time, were you two these charges for like $3, $2, $1? I don't know if these are all like phone games.
That's exactly what it was.
Okay, it looks like phone games to me. So these were all charged, at the time the two of you were you living together?
Yes, Your Honor.
All right, so you were living together, you were cohabitating.
Yes,
Who
Your Honor.
was working?
I was.
Okay, and Miss Davidson, did you have an infant at that time?
Father to that baby. So, what? That you chose to spend a few extra weekends with your kid. That's not the gotcha you think it is. Acting like you've uncovered some grand conspiracy because you voluntarily showed up for parenting duties is wild. Congratulations. You did the bare minimum required to avoid being nominated for the Deadbeat of the Year award. And honestly, if it's really that big of a deal to you, if these extra weekends are suddenly the hill you want to die on, then here's a revolutionary idea. Stop doing her any favors. Because let's be real, it's not like you were exactly Father of the Year when she was living with you. You weren't out here winning medals for effort. You weren't sacrificing your evenings reading bedtime stories or doing emotional labor. You were just occupying the same square footage and calling it parenting, so don't act blindsided now. Don't pull out the tiny violin and cry about how unfair it is that she asked you to step up for your own kid. If the workload feels heavy, it's because you weren't carrying your share in the first place. But by all means, keep performing outrage for the court. It's doing more to expose your priorities than anything she—
There's no year on ISC like 1106, 1217, 5320. It doesn't tell me the year these charges were made. Like, I can't tell from looking at the documents that were submitted when they were made. It just says year, or it says month and day.
That is fair, Your Honor, and I do have a stack of papers more than an inch thick of 4 years of bank records. I would be more than happy to bring to
Were you guys living together at that
Yes, Your
time?
Honor.
Okay,
It
so,
also showed that she emptied my checking account while I was providing for both her and a minor child. One of those instances occurred while I was at a grocery store with a shopping cart full of stuff, and she still emptied my checking account.
all right, but there's no claim for that in here. I mean, I just see the claim is that these are, I don't mean to call them micro transactions.
That's exactly what they are.
But they're like $1.05, $1.05, $4.69, 91 cents, $1.05.
Several hundred in total.
These are, well, what is you made a claim for $6,500.
Yes,
What is-
Your Honor, and if I may also point out that during the custody agreement, when we were ordered by the court week on week off custody on a dozen separate occasions, I made verbal agreement, which I'll quote Pennzoil v. Texaco, and that verbal agreements are enforceable. I made a verbal agreement with defendant to take child on defendant's court-ordered scheduled week so that she could go out with friends in exchange for her to do the same on my week, and I was robbed of that a dozen times on my weeks.
No. He's not letting you off the hook. He's dismissing your case under Rule 2.116C8, which is basically Michigan's equivalent of the federal Rule 12b6. What that means in plain English is that your lawsuit is being thrown out because it fails to state a claim on which the court could grant any relief. In other words, you don't actually know what you're doing, and the legal system just called your bluff. This isn't some technicality the judge is inventing to mess with you. It's a core principle of civil procedure. If your complaint doesn't lay out a valid legal claim, it doesn't matter how loud you yell or how passionately you believe you're right. There's nothing here for the court to act on. Your filing is fundamentally flawed, and the dismissal is not only inevitable, it's exactly what the rules are designed to do. Prevent frivolous lawsuits from wasting court time, so brace yourself. That case you thought was a battle about justice. It's about to vanish from the docket, and all that energy you spent building it up is about to be
I'm not a family law court. I mean, none of that is important to me. I have $6,500 of claim damages for a bunch of micro transactions that equal hundreds of dollars, and those transactions all occurred during the course of your cohabitation while you were the primary caregiver.
Yeah, Your Honor, that is correct, Your Honor. That is correct, Your Honor. And again, just to reemphasize that, again, not an iota of information or supporting documents or even be Texaco, whatever the legal scholar is quoting, has ever been presented to me, nor has this person ever contacted me. Again, he was rightfully served, Your Honor.
Well, it doesn't matter. I mean, if they're talking about making agreements outside of their parenting time order and one party's honoring them and the other party isn't, I am a district court judge. I do not do family law. I am not going to overstep my bounds and get involved in that. And certainly, I'm going to tell you my honest thoughts. I did family law for a long time. And if you two can't figure out how to get along on some level, you're going to screw your kid up. I'm just telling you, that's how it is. That's what I see here. And I see it all the time. And it's really disturbing to me because if you two talk poorly about each other, get mad at each other, in front of the child, can't communicate with each other, you are messing a kid up. You are. And I mean, and that's a family law matter. It's not in front of me, but
And Your Honor, I did represent.
I'm very sad to see it over and over and over again. Sir, do you have any other documentation that you want me to look at?
Your Honor, if I could actually go back to the motion in which defense made an effort to claim that my counsel never appeared.
Why do I care?
Because he's trying to have my case thrown out on multiple crimes.
I see what you're doing. You're trying to tell us you're an incel without actually saying it out loud. What you're really saying is, because things didn't go exactly the way I wanted, I expect a full refund for the food, clothing, and shelter I provided while she was under my care. That's right, you want compensation for basic responsibilities. Most adults would accept as part of parenting or a relationship. But here's the real kicker. If we're talking about fairness, shouldn't we also be asking if you're ready to pay her back for the 10 months she spent providing round-the-clock care for your child? You know, the kind of non-stop, exhausting work that doesn't come with a paycheck, but keeps a household and a kid alive. Oh, right, nope, not ready for that, so there you have it. You want a refund for your efforts, but the labor time and energy that actually mattered, you'd rather ignore that entirely.
No. Listen, he is trying to get your case thrown out by saying there's no relief and there's no claim, that there's no legal basis for your claim.
So
Is that you failed to state a claim on which relief can be granted. So I keep asking you, what matters to me is what documentation do you have that she owes you $6,500?
Your Honor, would a couple write a contract for who's going to pick up children from school any given day of the week? No, most couples are not. So in the same sense, if a couple is together and one party owes the other money, are they going to write a contract
Yeah, the answer is
No, and when one of the, so are you charging her for food she ate while she was the primary caregiver for your child and you were at work? Is she have to pay you back for the food she ate?
I'm asking.
I'm asking you a question, and guess what? I got the robe, sir. So I'm asking you a question. Does she owe you money for food, shelter, clothing that you paid for her while she was the primary caregiver for your child?
Your Honor, she does owe me for food, clothing, and shelter during the 10 months.
All I heard was defrauding by means of solicitation of services. So let me get this straight. You're essentially claiming that for 10 months straight, you had a live-in caregiver providing full-time care for your child. And somehow, according to you, you weren't obligated to compensate them? Let that sink in. If we were to put a market value on the work she was actually doing, feeding, clothing, supervising, cleaning up after not one but two little humans, 24/7s for 247 days, you'd be talking about a sum so high you'd need a signature from a bank manager just to issue the check. And let's be honest, even if you tried, your ability to pay that market rate would be laughably short. So while you're busy calculating what you think you're owed, the reality is that your claims collapse the moment someone applies a bit of common sense, and the court is fully aware of that. You're not negotiating a refund for groceries. You're trying to rewrite reality to make your negligence look like a transaction. And that's exactly why this argument is doomed from the start.
No. All right, listen. The request for relief in this case was the maximum that was allowed in district court in small claims. It's since been removed, but the amount claimed was $6,500. And the allegations were credit fraud, defrauding by means of solicitation of prostitution, possession of stolen property, promissory fraud, and emotional.
I'm sure having you in total control of every little aspect of her life was such a blessing to her, at least from your perspective, even if she might have experienced it a little differently. But hey, who's keeping score of feelings when you're running a one-person daycare and life coach operation at the same time, right? Now, all that's left is for the judge to step in and deliver the ruling. And given everything we've just unpacked, the overinflated sense of entitlement, the questionable accounting of services rendered, and the general parade of poor decisions, I have a feeling the courtroom is about to get a very clear reminder of how reality and courtroom logic don't always align with personal delusions. So buckle up, because the gavel is about to drop. This is where we find out exactly how the law views your self-made version of.
I do have several hundred hours of audio recordings held within my own home, as the Exhibit A submitted by the defense shows that the defendant was made aware that everything in my home was being recorded.
Your Honor, may I address the court briefly, Your Honor?
Very brief.
Thank you very much, Your Honor. As a practical matter, I represented my client also in the custody matter for like over the period of like almost a year. And respectfully, Your Honor, I'm not sure why this plaintiff feels he has a platform to do it, Your Honor. Again, there's no relief has been, nothing's been substantiated, Your Honor, and they actually took this serious, which I don't think he is. And again, I think it's a pure harassment technique. And he would have hired a lawyer, because that's why people pay a lot of money to go to law school.
All right. I mean, listen, Mr. Jaffe, we don't have to get in the mud though. Like, listen, as far as I'm concerned, I don't see any claim that relief could be granted on. I mean, all of these, when you have two people and look at, I'm going to just use common sense and reason. When you have two people who are cohabitating with a minor child, an infant, or a very young child, what year was the child born in? 2018?
February 2018.
So we're talking about a kid who is not school age,
Correct.
right?
She's 5 now and in kindergarten.
She's 5 now. But all of these purchases, all of these, what I'm calling microtransactions, all occurred while the two of you were in a relationship while the two of you were in a relationship, while she was the primary caregiver. And there are agreements that are made. I mean, you can look at it with common sense and reason, which is what I'm doing. And we're talking like, look, she likes phone games a little too much. I'll give you that, but you can't come a year and some after the parties split up and claim $6,500 in an action because of transactions that occurred. She clearly had access to money. Did your client go to the grocery store, Mr. Jaffe?
Of course, for the family, of course.
At the time, no, Your Honor, she did not. She did not have a license.
Absolutely. And again, Your Honor,
Yes. I have a court recorder. Do not make her suffer. She cannot type both of you at the same time. Okay, so you're telling me, Mr. Van Maren, that she did not ever have access to any bank account?
She had unlawful access to mine when she saved my credit information in her phone without my permission.
Okay, wait. So the whole time you were together.
My grandfather took me shopping.
So she was never allowed to go to the store or make any purchases?
She went with me.
And as a surprise to absolutely no one, the judge dismissed his frivolous claims. Honestly, it's moments like these that make me appreciate Judge Shackelford and the other judges from the 23rd District so much. They run their courtrooms with clear standards, enforce the rules, and absolutely refuse to tolerate any nonsense. It's refreshing to see a courtroom where decorum actually matters and people can't just wander in thinking the law bends to their whims. So, if you enjoyed watching this train wreck of entitlement get smacked down, go ahead and leave a like. If it wasn't your cup of tea, hit dislike, but don't skip the comment section. I want to hear your thoughts. And make sure to subscribe with notifications on so you don't miss any of the courtroom chaos and breakdowns I bring you. I'm Team Skeptic, and I'm out.
Statement. This is what you're telling me. She had no access to any money at all while she was staying home with this minor child.
She couldn't be trusted with money, obviously.
Okay. All right. I find that there is absolutely the plaintiff has failed to state a claim on which relief can be granted. We're talking about microtransactions that occurred during the relationship between the parties where they resided together and had a minor child, and Ms. Davidson was the primary caregiver for said minor child.
Your Honor,
Sir, you have, if you want to file an appeal, sir, you are certainly entitled to that relief.